They asked or faxed me requesting the $25,000 to go into a particular bank account. I faxed them back and I said, could you give me the ABN number and the ACN number for the new state of Western Australia in consideration of the fact that you've removed yourself from the Crown? They faxed back and said, we don't have that. I faxed back and said, well, when you get yourself legal, send the next one. And that was the end of the correspondence at this point. So what we're actually saying here is I'm dealing in criminal jurisdiction, they're still stuck in civil, but they've got the Aussie walking up the chute to a trap. The trap will be the plebiscite, put there by Bob Brown. And you'll find it on your electoral paper. If you've got that far, you're in big trouble. Because once that is ticked, they'll lock you out of the referendum. And that's why they've been bypassing the referendums now and why they've been changing the laws in relation to the courts. Now, I'll give you an example of this. One of the judges, he said to me, I said to him, you'd be sitting in buyer's net. That was Chris Maxwell. And the reason why I said to be sitting in buyer's is because I've got 6 of the judges charged in that court, so that they're actually looking after their mates. To which he honestly said, we were discussing that when we were roving, which meant we know we're sitting in bias. I said, well, put the bias aside. Aren't you now in breach of Section 34 of the Crimes Act 1914? To which he pulled the book out and he read it to the court. And this is what it says. A judge or magistrate exercising federal jurisdiction with a personal interest, 2 years jail. It never appears in a bias paper. I said, Your Honour, haven't I caught you fair between the middle stump? I said, but I'll lift the bat, I won't charge you. Because when we do the real grand jury hearing, I'll need you on the bench because they're the only honest one left in the pack. He looked at me and sort of said, I'll tell that to my wife. And the bloke reckons I'm honest. He was honest because he said we were discussing that when we were roving. An honest man wouldn't have said that from his bench. Meaning we shouldn't be hearing this matter at all. That's exactly what I said. Now I said it's just between you and I. I'm the person who's laid the charges. Here's the olive branch. I'll let the charges sit, sine die, and make it a trial of the issue. And let it go to the grand jury to get the indictment, and then the indictment goes to the trial, and the trial is a trial of the issue. Is that fair? Because if you don't do that, you will destroy your whole legal process, everything that you thought you had. But does it need a state trial of the issue? And the only way Section 80 of the Commonwealth Constitution activates is it says trial on indictment shall be by jury. The only place you can get an indictment, because do you think the Commonwealth DPPs are going to let you get one? Do you think the state DPs are going to let you get one? The only place you can get an indictment is from the grand jury. And all you have to do is put a letter, an official letter, to the full court of the Supreme Court in Victoria and say, we now know you have been concealing the grand jury hearings that are pending. You have 7 days to fix this problem. Can you write such a letter? And do it officially, legally and graciously. But now you're going to put pressure on that court because they're already now caught with Section 34, which starts 2 years jail anyway. The judge then said to me, Mr. Shaw, it must be in federal jurisdiction to activate. I said, Your Honour, with respect, any court hearing any matter in a constitutional issue is automatically sitting in federal jurisdiction. You know that, so do I. You're in federal now. And what's the personal interest? You're looking after your mates because you know that they can't go to the grand jury or the grand jury's going to indict them. And your mates are gone. So I said, that's your personal interest. It's what you call mates rates. Any other question? Stand up, please.
In relation to the removal of the Oath Act, what is the practical effect when dealing with solicitors and the practical effect when dealing with a magistrate or one of the lower courts?
That's a loaded question. First off, is any magistrate sitting in valid jurisdiction in the Commonwealth? Yes or no?
No, not usually.
Why? Because you've got one word in the Commonwealth Constitution preamble that none of us are paying any attention to. The word is indissoluble. It's in your Commonwealth Constitution preamble. It's not in the UK, it's not in the United States Constitution, it's not in the Canadian Constitution, but they put it into yours. What it means in law is you cannot touch it to 100th part. Did they touch it in Victoria? Did they touch it in Western Australia? That puts every magistrate and every judge into a really bad jurisdictional problem. Here is the key. Never hoist the jurisdiction of a court. Never hoist the jurisdiction of a court. By a lot of people say, I don't submit to the jurisdiction of the court. That's the biggest mistake you're going to make in this issue. Because the moment you challenge the jurisdiction, you're actually defeating yourself. This is the correct way to do it. Your Honour, with respect, I challenge the jurisdiction of you to sit in this court. A huge difference. Because they're the offender sitting in the court, not validly constituted. Do you see the swing? And if you understand the swing, you've got good grounds. Otherwise, if you challenge the jurisdiction, I've seen, excuse the expression, whackers challenge the jurisdiction and walk out the door. Well, you're going to get nowhere. You're going to have an order following you out that'll probably end up losing your farm, your house, or whatever. This is what Kim Beazley said in Hansard's. We can't find Hansard's for it. Somebody removed it. Apparently in 1990, in answer to a question from Senator Button. He said the United Nations has given the federal parliament a mandate. Now, can I stop there and ask, who the hell give the United Nations a mandate to tell the federal parliament what to do? So he automatically showed you who the player is. The United Nations has given the federal parliament a mandate of government control of farms, houses, businesses once the republic is proclaimed. Take that document off the table and you're going to get UN control. Is that what you want? Okay, why were you not paying attention to your law? This man over here honestly admitted he's never read the Queensland Constitution.
I read the Australian one, 1900.
You've got a Queensland one too. You're in the state of Queensland. And the state of Queensland is bound to section 106 of the Commonwealth Constitution Act. And it states that you must do all things according to the Parliament's manner and form. Now, what is manner and form? Manner and form is any state referendum requirement must be abided by, because if it was not, the legislation created is not valid. You need to read that section. And then if you come into the Australia Act and see section 13 of the Australia Act, it states this, that any legislation created without abiding by its correct manner and form is invalid from its inception. So the Australia Act has its own demise at section 6. Because of section 53 of your Queensland Constitution. Anybody issued a writ. Now, take them on, watch them, duck for cover, but you just simply say, Your Honour, you are not, this is the correct legal term, for anyone who has already been through the process, you are allowed to issue a new writ. Do you know that? Are you aware of that? So even when you think you're in the 5th level of the appeal, go back and issue a new writ. You're allowed to do that. This is the key of the new writ. All judgments prior to this were obtained by fraud because the court was not validly constituted. Did you get those words? Now, they've got huge, huge, huge legal things to jump over with those words because fraud vitiates everything. Has this uncovered fraud? Yes. Is the judges sitting in this fraud? Yes. Are the magistrates sitting in this fraud? Are the Attorney General sitting in this fraud? Because you are a grand jury. It's what you call a de facto common law grand jury, but until you have these hearings, you don't know there's something wrong. And you have the ultimate power to say to them, there'll be no election until you deal with that problem. Or alternatively, if you hold one, you'll all be charged. Are you going to issue the charge sheet? Because when I first went to the Melbourne Magistrates Court with my charge sheet, I said to the guy at the bench, he then saw it was of the Supreme Court of Victoria. He said, "Hell, look who that is. I'm not signing that off." And I said, "Well, cross him out and put you there. Because you're the one concealing it. I'll charge you." And he looked at me and said, "Leave it with me for a couple of days." And now when I go to that portion of the desk, it's like, they will move over there. And I go, "Here comes the treason bloke." Because there's only one man at that court allowed to deal with me. Because they all know, you make a mistake, I'll charge you. Even when, in one time when the DPPs come, one of my friends, and at this time there was 8 of us who laid charges, and the DPPs hand out a takeover document just before it's all ready, as in we're taking over, to which he got and said, "That lady over there, she gave me a document that said they're taking over, but I can't see her signature, so I really don't know her name. Your Honour, can you get her to tell us who this is?" And he looked at it and said, "They're looking for your name." And she stood up and said this, "I'm not giving it." And the man said, "Why?" And they said, "Because they charge it." Of course they So here comes the point. Here's your piece of paper back. Can the DPPs indict the grand jury? Can the Attorney Generals indict the grand jury? Can the Governor General do anything with the grand jury? Can the grand jury indict the lot? Well, who's got the biggest stick here? Why don't you exercise it? Oh, good point. Good point. Let's start with how. Write that letter to the President of the Court, of the full Court, the President of could you find that picture? Chris Maxwell, please. Yeah, I'll help you here. And please, I'm not practicing law in the state of Queensland. Now, the reason I say that is quite comical, because in Western Australia, one judge said to me, when I filed an affidavit for another person with my name on the affidavit, they said, "Mr. Shaw, you produced that affidavit. You go and sit in the back of the court because I'm going to charge you for practicing law illegally in Western Australia." A year later, those 3 judges were on the bench, and I said to them, "Your Honour, with respect, because you took the oath of allegiance out of the Supreme Court Act, you took the Crown out of the Supreme Court Act, you took a Majesty out of the Supreme Court Act, you actually offended to treason. With respect, Your Honour, you're under arrest. The charge is treason." With 140 people in the courtroom. And they look at me like, we thought that might be coming. And then I just left. And that all went to the Melbourne Magistrates Court. They showed up, the boys from Western Australia, to say this: "Mr. Shaw had no jurisdiction whatsoever to bring a West Australian problem into this court. He's crossed over the borders, he's affected cross-vesting jurisdictional problems. He has no jurisdiction to do that." To which the magistrate said, "Are you here looking for costs for that?" I said, "Yeah." And he said, "Well, aren't you thinking on your feet?" To which the barrister's light came on in his head. He said, "Well, I guess I am." What the magistrate meant was that if he had no jurisdiction to do it, you've got no jurisdiction to follow him in after looking for costs. So I had to see and relax your brain for a little while. And that's what happened. Because a police officer said to me in Western Australia, "But how did you jump over the cross-vesting jurisdictional problem?" I said, "That's real easy." He said, "But how?" I said, "Well, when you took the Crown out, you don't legally exist as the state of Western Australia. So I didn't jump over nothing because you don't legally exist." And he thought, "Well, that's so simple it can't be funny." And that's the reality. Now, how can Western Australia vote in the coming election if the Crown's out? Are you going to let it do that? So you start issuing your legal notices now, and you must write to the chief, sorry, not the chief, there he is, Chris Maxwell. Now, he's not the President of the Court of Appeal for this jurisdiction. He's the President of the full Court of the